Hi, my name is Zi Xuan, and today's presentation will explore a complex legal scenario in public international law, one that highlights the growing tension between treaty stability and rapidly evolving global challenges. The dispute in question concerns a bilateral treaty between State Aramaica and State Botswana regarding a joint dam project constructed along a shared river. A decade into the project's operation, State Aramaica decided to unilaterally suspend the treaty. It claims that State Botswana has persistently failed to comply with environmental safeguards included in the agreement, thereby committing a material breach. According to Aramaica, this breach strikes at the very heart of the treaty's object and purpose, and thus justifies suspension under international law. However, State Botswana strongly disputes both the facts and the legal justification. It argues that the environmental safeguards are outdated due to the long-term impacts of climate change. It invokes the doctrine of rebus sic stantibus, a fundamental change of circumstances, to argue that it cannot be held to environmental standards that no longer reflect present realities. Furthermore, Botswana contends that a recent United Nations General Assembly resolution recognizing access to clean water as a fundamental human right elevates that right to the status of jus cogens. In its view, the continued implementation of the dam project, which diverts substantial water flow, is incompatible with this overriding norm of international law. This presentation will proceed in 5 parts. First, I will outline the relevant legal doctrines and concepts as established in the Vienna Convention on the Law of Treaties. Second, I will apply those principles to the facts and arguments presented by each state. Third, I will critically evaluate the strengths and weaknesses of the legal position involved. Fourth, I will offer concrete recommendations aimed at resolving disputes of this nature in the future. And finally, I will conclude by reflecting on the broader implication for treaty law and the future of international legal governance. Now, let's move on to part 2 of the presentation, which is legal framework and concepts. To assess the legality of State Aramaica's treaty suspension and State Botswana defenses, we must examine 3 core provisions from the Vienna Convention on the Law of Treaties, namely VCLT. These are Article 60 on material breach, Article 62 on fundamental change of circumstances, and Article 53 on jus cogens or peremptory norms of international law. Let's begin with Article 60, which permits a party to suspend or terminate a treaty in response to a material breach by another party. A material breach refers not to just any violation but to one that strikes at the essence of the treaty, specifically a provision essential to the accomplishment of the treaty's object and purpose. Importantly, the breach must be serious and not merely technical or procedural. The International Court of Justice, or namely ICJ, has noted in past decisions that states should exercise caution and restraint when invoking this article. Suspension or termination is a severe action with implication for stability and reciprocity, and should only be used when peaceful remedies have failed. Next is Article 62, which codifies the doctrine of rebus sic stantibus, which is a Latin phrase meaning things thus standing. This principle allows a party to withdraw from a treaty when a fundamental unforeseen change in circumstances have occurred, rendering the continued performance of obligation radically different from what was originally agreed. However, the bar for invoking Article 62 is very high. The change must not only be unforeseen but must also concern the circumstances that were the essential basis of the treaty. Furthermore, the change must radically transform the extent of the party's obligations. Because of its potential to undermine treaty stability, Article 62 is applied narrowly. Finally, we come to Article 53, which concerns jus cogens or peremptory norms of international law. These norms are considered so fundamental that no derogation is permitted, even by agreement. If a treaty is found to conflict with a jus cogens norm, it is void. Classic examples of jus cogens include the prohibition on genocide, torture, slavery, and aggression. For a new norm to attain this status, there must be widespread and representative state practice along with opinio juris, which is a belief that the norm is legally binding and non-derogable. Overlying all of this doctrine is Article 26, which sets out the principle of pacta sunt servanda, treaty must be performed in good faith. This principle is foundational to treaty law and underpins the mutual trust necessary for international cooperation. Yet, as we will see, it must be sometimes reconciled with competing principles such as environmental justice and evolving human rights standards. My presentation will proceed to Part 3, Application and Case Analysis. With the legal framework established, let us now apply this principle to the action of State Aramika and the counter-argument raised by State Botuna. Beginning with Aramika's suspension under Article 60, the key question is whether Botuna's failure to adhere to environmental safeguards constitute a material breach. For Aramika to succeed, it must show that these safeguards were essential to the treaty's object and purpose and that Botuna's breach was both significant and persistent. This is not a low threshold. Environmental provision often form a critical part of bilateral water sharing agreement, especially where transboundary ecosystems are at stake. If the dam project was intended not only to generate shared economic benefits but also to protect river sustainability, then violation of environmental clauses could indeed be seen as material. However, international jurisprudence urges caution. The ICJ's ruling in the Gajikavo-Nagri Maros project between Hungary and Slovakia is particularly relevant. In that case, Hungary attempted to suspend its treaty obligation concerning a joint dam on environmental ground. The ICJ acknowledged Hungary's concern but ultimately found its unilateral suspension unjustified. It emphasized the importance of procedural obligations, particularly the duty to negotiate and seek cooperative solutions before resorting to unilateral action. Aramika must demonstrate that it exhausted people's means and that suspension was proportionate to the scale of the breach. Turning to State Botuna, its first defense rests on Article 62 invoking robust 6 thunderbirds. It argues that climate change has fundamentally altered the hydrological and ecological circumstances underlying the treaty. While this reflects an important reality, the legal test under Article 62 remains stringent. First, climate change, while intensifying, is no longer unforeseen. Global awareness of its effects has been widespread for decades. Second, Botuna must prove that the change radically transforms its obligation, not just made them more burdensome or inconvenient. Unless Botuna can show that continuing the treaty would lead to fundamentally different or harmful outcomes than those originally envisaged, its claim is unlikely to succeed. Botuna's second defense is more ambitious. It claims that the right to access clean water has become a peremptory norm of international law. If true, this would render the treaty incompatible with jus cogens and therefore void under Article 53. In support, Botuna cites the 2010 UN General Assembly resolution recognizing water and sanitation as human rights. This resolution, while symbolically important, is not legally binding and does not on its own establish jus cogens status. To elevate a norm to peremptory status, state must demonstrate consistent practice and a shared belief that the norm allows no derogation. So far, no international court has recognized the right to water as a jus cogens norm. In Al-Asani against United Kingdom, the European Court of Human Rights acknowledged the existence of peremptory norms but refused to prioritize them over state immunity in that instance. Similarly, in the jurisdictional immunities of the state case, the ICJ ruled that procedural rules were not automatically displaced by jus cogens. This decision reflects the judiciary's caution in expanding the scope of peremptory norms. Therefore, while Botuna's argument highlights real humanitarian concern, it lacks strong legal precedent. Its position may be persuasive as a normative appeal than a doctrinal one. It might help influence the future direction of international law, but under current standards, it remains a legally uncertain defense. This case exposes the limitation of traditional treaty law in addressing contemporary global crises. Moving forward, I offer several recommendations that would make international treaty law more responsive, flexible, and just. First, future treaties should include climate-sensitive adaptation clauses. This would allow states to revisit and revise obligations periodically in light of changing environmental conditions, Such provision would reduce the reliance on vague doctrines like robust extendibus and offer structured legal pathway for treaty evolution. Second, states should commit to neutral third-party review of material breach claims. Article 60 currently allows a state to suspend a treaty based on its own assessment of breach, while creates risk of political misuse. Instead, treaty bodies or independent arbitral panels should be empowered to assess whether a breach is genuinely material and warrants suspension. Third, international bodies should explore the formal codification of the right to water as a jus cogens norm. This would involve collaboration between the UN, the International Law Commission, regional human rights courts, and the international scholars. If a broad consensus emerges, it could transform the right to water from aspirational rhetoric into enforceable legal principle. Fourth, legal education and treaty practice should promote a more dynamic understanding of pacta sunt servanda. Good faith should not be interpreted solely as rigid compliance, but also as the willingness to interpret obligation in light of compelling humanitarian or environmental needs. This aligns with the growing recognition that legal certainty and legal justice are not mutually exclusive. Finally, regional institutions and multilateral framework must be strengthened to resolve future treaty disputes collaboratively. Bilateral breakdowns often reflect broader systematic failures, and long-term solutions require multilateral engagement, technical expertise, and political will. To conclude, the dispute between State Aramika and State Botuna demonstrate the challenges of applying established treaty law to fast-changing global contexts. Aramika's justification under Article 60 appears legally stronger if it can prove a material breach of essential obligation and show that peaceful remedy were pursued. In contrast, Botuna's reliance on robust extendibus and jus cogens reflect forward-looking legal thinking, but its claims face significant doctrinal barriers under current law. This case invites us to think critically about the future of international law. As climate change, water scarcity, and human rights concerns become more urgent, the rigidity of treaty drafted decades ago may no longer serve us well. Law must not only preserve the past, it must also anticipate the future. Public international law must evolve from a system of static promise to one that recognizes shared responsibility in a world that is increasingly interdependent and ecologically fragile. Our responsibility as future lawyers and policymakers is to shape international law not just to reflect existing rules, but to respond courageously and intelligently to global change. Thank you.